First matter to come before the court this morning is State of Ohio v. Alfonzo Johnson. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, if you let me know when you get started, I'm keeping the clock and I can keep you apprised of the passage of time. We've read the briefs and we're ready to see who you are. Thank you.
Please the court. Good morning, Your Honors. My name is Attorney Denise Williams, and I represent the appellant Alfonzo Johnson in this matter. In my time before the court, I will challenge the convictions for sufficiency of the evidence and manifest weight of the evidence. The court should find in favor of Mr. Johnson because the evidence failed to show at trial that Mr. Johnson committed a theft offense or an aggravated robbery with a firearm specification. And since the evidence failed to show that his conviction must be reversed. Your Honors, in judging the sufficiency of the evidence, the court should determine whether evidence in the trial, if believed, would convince the average mind of the defendant's guilt beyond a reasonable doubt. Here, whether the evidence was uncontradicted is an issue that the Ohio Supreme Court has determined is one of the factors. The witness in this case, one of the witnesses, Charnel Tucker and James Price, they were the two stated victims in this matter. They said that Mr. Johnson had come to their house and robbed them at gunpoint. There was another witness also, Your Honors, that his name was Brian Price. He was the best friend of the two individuals, and he stated that these individuals were on heroin at the time and that they were pretty messed up mentally. He also stated that earlier in the day that Mr. Price, one of the alleged victims, had called him, accusing him of robbing him that day. And once he indicated to them that he had an alibi, they then turned their attention to Alfonzo Johnson because they allegedly saw him driving in the neighborhood with his girlfriend, Amber Nettles, that day. At trial, Amber Nettles testified that she did not take Mr. Johnson in that area to rob anyone, and in fact later that night they had gone to the movies. It was the end of the month, and she said that they had dug up change from the couch in order to go to the movies. Also, Your Honors, James Price, who had testified in this matter, stated that he was watching television and that Mr. Johnson had come over and that Mr. Johnson had pulled a gun out and said that if you touch it, I'll blow your head off. However, when Charnel Tucker testified, she stated that she doesn't remember that ever being said. Also, James Price had indicated for the first time at trial that in addition to a gun and money and cell phones being taken, that 75 ecstasy pills were also taken. Mr. Johnson stated that at the time of the robbery that Mr. Price stated that at the time of the robbery that Mr. Johnson had pulled an automatic on him, that the gun was an automatic. And when Ms. Tucker testified, she testified in describing the weapon that it was described more as a revolver and not an automatic weapon. Further, Charnel Tucker also could not remember what Mr. Johnson was wearing. The officer in this case, his name was Officer Barbie, and when he began to investigate this matter, he had talked to Ms. Tucker and Mr. Price, and he conducted no follow-up investigation with any witnesses. There was a third witness that was Brandon Whitfield, although he wasn't advised of this person at first. Later on, he was advised that there was a third witness in the house that witnessed the robbery. However, he was not robbed. Mr. Barbie, or Officer Barbie, never interviewed Brandon Whitfield to determine the credibility of the statements made by Mr. Price and Ms. Tucker. He also never verified whether there were any cell phones that were actually taken by them. Although they stated that there were cell phones taken, they he did not ask them the subscriber information or follow up with the the telephone company to try to track the phones or to find out, in fact, if there ever were any phones that they had in their possession or under their name. Also, Mr. Tucker had indicated that he purchased the weapon that was stolen, which was a 9mm Kel-Tec automatic. Mr. Price is stating that Mr. Johnson stole that weapon, and he told Officer Barbie that he purchased this weapon prior at a store called the at a gun store, and at the time, Mr. Barbie, it's called B&T Gun Shop, and so Officer Barbie went to the B&T Gun Shop to try to locate the serial number and any records for the weapon. However, the gun shop had no record that a gun such as that was ever sold to Mr. Tucker, and he could not verify that a gun even existed. Furthermore, Officer Barbie indicated and stated on the record that James Price and Ms. Tucker could have been lying to them or to him about the incident, and that he only interviewed them one time. So this entire trial was based on an interview by an officer, and it was very limited in nature of the investigation. One of the other factors that the Ohio Supreme Court has said that the state or the court could consider the sufficiency of the evidence is whether a witness was impeached. Both Ms. Tucker and Mr. Price, not only were they on heroin according to their friend Brian Price, but they also have convictions for theft and dishonesty.
They testified in the trial, right?
They did, Your Honor. And what was not proved, again, is the fact, which is one of the other factors to consider, is that there were no fingerprints, there were no photographs, there was no weapon that was ever located that my client, Mr. Johnson, was alleged to have used and brandished in the course of this crime, which led to his 3-year firearms specification conviction. Another factor, the reviewing court is not required to accept that incredible is true. We would submit that the testimony of Mr. Price and Ms. Chanel Tucker is incredible, and that based on the evidence of their best friend, this Brian Price, that they were on heroin, and most importantly, the fact that they in fact did accuse him of being the one to rob the house earlier.
Counsel, it seems like, from reading the briefs, that we have pretty much everybody who's involved. All the actors are what I would call unsavory characters. They all have some criminal involvement. And so it was really for the trier of fact to sort out from their backgrounds, and then looking at the evidence, what was most likely true. So even though the victims had their issues, your client was captured on the telephone making certain calls that implicated him. The other guy, the best friend, Brian, apparently was incarcerated with your client.
That is correct.
And there was some issue as to whether or not he had threatened to beat up somebody. I mean, it's like there's enough stuff to go around.
Well, you know, Your Honor, I would agree to a certain extent, but the fact that Mr. Price and Ms. Tucker were the only ones who had anything to say about the robbery, I think is deficient, because Mr. Brandon Whitfield, who was present, was never interviewed, was never brought in as a witness, and
that goes more to the weight than sufficiency.
Right. It's
if they just
weight.
say that it happened, that is enough. If the jury, if we, consider the facts in a light most favorable to the state.
Well, in regards to the manifest weight of the evidence, the court can look at whether all elements were proven beyond a reasonable doubt. One, by reviewing the record, weighing the evidence, consider the credibility of the witnesses, and determine whether the triers of fact lost their way. So in regards to the credibility of the witnesses, the two main eyewitnesses are not credible because of their history, because of the fact that they had none of their information could be corroborated by the officer. There was no interview that was conducted toward Mr. Johnson, his girlfriend, Brandon Whitfield. There are several deficiencies in this case, Your Honors, that we would ask the court to consider in determining that the evidence was against the manifest weight and the sufficiency of the evidence.
I have a question regarding the woman who was alleged to be driving your client. Did she testify?
She did testify, Your Honor.
And did she testify that she was driving with him earlier in the day?
Yes, but she never said that she was in that area with him.
Well, she was with him somewhere.
Yes, that was her boyfriend.
Okay, I understand.
Yes.
And just remind me, was this a trial to the court or to a jury?
That was to a jury, Your Honor.
Thank you.
He initially entered a plea of guilty, withdrew the plea, and then had a jury trial.
Thank you.
And then at the trial, he was convicted of two of the counts, the original counts were dismissed, so he was convicted of counts 4, 5, and no sentence in count 3 due to election by the state. So he received 4 years in prison on count 4, 6 years in prison on count 5, and then he had the additional 3-year gun specification. In regards to the theft, Your Honors, there is a 1-year firearm specification that if the court were to say that Mr. Johnson had stolen a weapon, and therefore that was one of the reasons for the 1-year firearm specification. Again, there's no evidence that a gun ever existed, and in checking and verifying the fact that this gun did exist, there was no information that was available. Your Honors, these facts mandate the conclusion that Mr. Johnson did not commit these crimes, and therefore the court should find in favor of the appellant, Mr. Johnson, by reversing the judgment of the trial court. Thank you.
May it please the court, my name is Natasha Guerrero, and I represent the appellee of the state of Ohio in this matter. First, with regard to the sufficiency argument, in reviewing a conviction based upon an argument of lack of sufficient evidence, this court must review the evidence as both believable and believed, and in the light most favorable to the state. And as Judge Moore stated, the testimony of both James and Charnel in this matter was sufficient in order to convict Mr. Johnson of the charges that were against him. Both testified that Johnson entered their residence on July 31st, 2012 through the back door, that he sat at a table while they sat in the living room on the couch watching television. And they both described that Johnson was there for a short period of time, and that he pulled a weapon, which they both described as a long barrel revolver, from his pants, pointed at James, demanded everything that he had. He provided him with his cell phone as well as whatever money he did have on his person, and he also, Charnel also provided him with a cell phone. And the testimony of both of them also was that Johnson asked about a weapon. James indicated that the weapon was actually under the couch. At first, Johnson stated, "Retrieve the gun for me," but then decided, no, I don't want him to get the gun, I'm going to get it myself. And they both described that Johnson lifted the couch with one arm, retrieved the gun, and then after that left. And therefore, in viewing that testimony as both believable and believed by the jury, and not going into a comparative weighing of any sort of facts, which would be left for a manifest weight argument, the state provided sufficient evidence of a guilty verdict for the charges against Mr. Johnson. It is in that manifest weight argument that you go into the actual review of the entire record, looking at and making all reasonable inferences, as well as considering the credibility of the witnesses. In reviewing the credibility of the witnesses, however, there should be granted some deference to the trier of fact because they were in the best position at that time to actually view the witnesses as they testified and could make that credibility determination based upon their actions and how they presented themselves in court. And here, based upon the jury's verdict, they believed the account of what transpired that was provided by the state through James and Charnel. And the issues that Mr. Johnson is pointing to does really weigh on this credibility determination that should be granted deference through this court with regard to the jury's determination. There were obviously some minor inconsistencies in James and Charnel's testimony as to whether who answered the door. The state would submit that actually James and Charnel did provide a consistent description of the gun that Johnson actually used. And whether or not they called the police thereafter, but both did testify that after the fact, a little while later, they did go in and report this incident to the police.
And they were pretty transparent, I imagine, as they had to be, that the reason why they didn't want the police there was because they had drugs in the house.
That is correct, and that is part of the reason also. James stated that that was the reason why he didn't want the police actually to come to the residence, and that also is a reasoning that he provided for not saying that Mr. Johnson also stole some ecstasy pills, because he felt if I provided that to the police department saying, hey, he stole pills too, that he could get himself into trouble with regard to his drug trafficking activities.
What about this Whitfield person who was not mentioned? What's the state's theory about the fact that he was not disclosed as a witness?
There was some testimony that James Charnel may have not initially provided his name. However, it did come up prior to actually going to trial. And Detective Barbie said that once he got that information, he actually attempted to track down Mr. Whitfield, but was unsuccessful in being able to do so. So, although initially it was not disclosed, that was eventually provided to Detective Barbie, and he did his best in order to try to track down this witness and attempt to get him in to get a statement from him regarding the incidents that occurred in the residence. And with regard to Amber Nettles, the state also presented those jail calls between her and Mr. Johnson after he was arrested. And his statements also implicate him during those phone calls, implicate him with regard to these incidents, and say asking her to actually talk to James. She offered to pay them off, to actually sit with him so that they would not come to court, because he made several statements during those jail calls also that if the witnesses don't show up, the charges would be dismissed against me. So that all lends also to the fact that the testimony that was provided by James and Charnel, the incidents that occurred, was actually what took place. And lastly, with regard to Brian Price, there was also, as Judge Moore pointed out, some issues with regard to his testimony as well. He testified that he provided a statement that he didn't know how Johnson's name got involved in all of this. However, during his testimony, he said, I was the one who actually provided the names to James and Charnel. And also there was some interesting timing with regard to the statement as well, because there were also some jail calls in which Brian Price actually threatened James Price in what appeared to be stealing of some clientele in the drug trade. And that took place a few weeks prior to him making the statement, as well as the fact that he was also incarcerated with Johnson at the Lorain County Jail prior to. So the state would submit that the manifest weight of the evidence actually does support Johnson's conviction as well as the sufficiency of the evidence. Therefore, the state would request that this honorable court uphold the convictions and overrule the assignments of error that Mr. Johnson has provided. Thank you.
Thank you. Counsel, do you wish to rebuttal time? You have about 3 minutes remaining.
Nothing further, Your Honors.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted on the Supreme Court website. Thank you.